government service. I don't give a damn what they say about me as long as I'm succeeding in the mission. We're succeeding in the mission because the men in 38 times. That is how many times Kash Patel communicated with an outside law firm through channels that bypassed every official FBI logging system in just 51 days. Not emails through bureau servers, not calls on government lines, not documented consultations that career agents could review or oversight committees could request. 38 contacts off the record, invisible to the institution he was supposed to be running. And then in the weeks that followed those 38 contacts, a federal investigation into approximately $1.7 billion in financial transactions was quietly shut down. No press release, no official explanation, no documented legal basis entered into the case file, just closed. Jasmine Crockett walked into that House Oversight Committee hearing with one FBI internal review report and a single prior sworn statement that Patel had made to Congress. She didn't need anything else, because the distance between what Patel told Congress under oath and what his own agency's internal review documented is not a gray area. It is not a matter of interpretation. It is a contradiction so complete, so documented, so inescapable that when Crockett placed that single document on the table and looked at Patel, every attorney in the room understood what was about to happen. Stay with me until the very end. Because the trap Crockett built slowly, methodically, one question at a time, is the most precise piece of congressional accountability work this hearing cycle has produced. And the moment it closed, Patel had nowhere left to go. The House Oversight Committee session had the feel of routine when it began. Patel arrived prepared, talking points ready, legal team positioned, answers pre-cleared for every question he expected. He had sat in enough of these rooms to know how to run the clock. He had not prepared for Jasmine Crockett. Crockett is a civil rights attorney from Texas who understands the architecture of a legal trap, how you build the foundation before the subject knows what you're constructing, how you close every exit before asking the final question. She opened with something that looked on the surface completely harmless. Director Patel, she said, her voice carrying the relaxed precision of someone who is in no hurry. I want to start with something basic. Can you walk this committee through how the FBI documents official decisions? Specifically, when a significant investigative decision is made, a closure, a reassignment, a change in case status, what is the standard documentation process? Patel settled into the question. It felt safe. Process questions are safe. They allow a witness to demonstrate competence, to project institutional authority, to occupy time with answers that can't be challenged. The Bureau maintains comprehensive documentation protocols for all significant case decisions, he explained. Field agents compile reports, supervisors review and authorize. Everything moves through official channels and is logged in Bureau systems with appropriate timestamps and authorization signatures. Everything goes through official channels, Crockett said, and official channels means documented, logged, accessible to appropriate oversight functions. Correct. Thank you, Director. She reached into her folder. Now, I want to show you something. She placed a single document on her desk, face up, the FBI seal visible in the header. She didn't hold it up dramatically. She didn't announce it. She just put it there between them and looked at Patel with an expression that was completely neutral. This is an internal FBI review report compiled by the Bureau's Office of Professional Responsibility between March and April of this year. I want to ask you about one specific section. She opened to a marked page. This section documents communications between the Office of the FBI Director and external legal entities during a 51-day period beginning January 22nd. According to this report, during that 51-day period, there were 38 instances of contact between your office and a private law firm conducted through channels outside official FBI communication systems. Off-channel, undocumented in bureau logs, not accessible to standard oversight review. She looked up. Director Patel, you just told this committee that everything goes through official channels and is logged in bureau systems. How do 38 off-CH communications with an outside law firm exist in an internal OPR report if everything goes through official channels? The room shifted. That specific atmospheric change that happens when a hearing moves from procedure into something with actual weight. Journalists straightened. Committee members looked up from their phones. Patel's lead attorney moved forward slightly in his seat, the involuntary lean of someone who has just seen the ground change under their client's feet. Patel reached for the standard response. Congressman, communications between the director's office and external legal counsel can involve matters of attorney-client privilege that necessarily occur outside standard bureau logging systems to preserve that privilege. 38 times, Crockett said in 51 days. The volume of consultations reflects the complexity of I want to ask about the subject of those consultations. She turned another page. According to the same OPR report, the external law firm involved in these 38 off-channel communications, Mercer, Aldrich, and Webb, currently represents clients with financial interests in matters that were under active FBI investigation during the same 51-day period. She looked at Patel steadily. Asterisk, were you aware that the firm you were communicating with off-channel had clients with active FBI cases? Patel's jaw tightened. Just barely. I cannot speak to the client relationships of external legal entities. You can't speak to them, but you communicated with them 38 times without logging those communications in bureau systems. Crockett's voice remained perfectly level. Director, are you familiar with the FBI's conflict of interest protocols governing director-level communications with outside counsel? I am familiar with all applicable protocols. Then you know that those protocols require disclosure of any potential conflict of interest before engaging external legal consultation. Was a conflict of interest disclosure filed in connection with these 38 communications? Silence. 4 seconds. 5. I would need to review the specific documentation. It's a yes or no question. Director, was a disclosure filed? More silence. I am not aware of a specific disclosure filing in that context. Stop right here. If you are still watching, hit the like button right now because Patel just confirmed on the record under oath that he engaged in 38 off-channel communications with a law firm whose clients had active FBI cases without filing the conflict of interest disclosure his own bureau's protocols require. That fact is now in the congressional record, permanent in Patel's own words. But Crockett wasn't finished. The 38 communications and the missing disclosure were the foundation. What she built on top of them was the structure that made everything else collapse. Director Patel, I want to ask you about an investigation. Case file reference FN 2024 CR00091, a financial crimes investigation into approximately $1.7 billion in transactions flagged for potential wire fraud, money laundering, and Bank Secrecy Act violations. Are you familiar with this investigation? Patel's expression shifted. A fractional change, the eyes moving slightly, the breathing changing pace for just a moment. I am aware of various financial crimes matters that have come before the Directorate. This specific one fine 2024 CR00091 $1.7 billion. Are you aware of it? I would need to review case-specific materials. It was closed. Crockett said on March 14th of this year, 43 days into your 51-day off-channel communication period with Mercer, Aldrich, and Webb. Closed without a documented legal basis entered into the case file. Closed without a supervisory review memo. Closed according to the career agents who had been working it for 14 months without any explanation provided through official channels. She paused. Director Patel, did you authorize the closure of FN 2024 CR0091? The room was absolutely silent because everyone present had just done the same calculation. 38 off-channel communications with a firm whose clients had active FBI cases, no conflict of interest disclosure. And then a $1.7 billion investigation closed without documentation, without explanation, without any of the standard procedures that Patel himself had described minutes. Earlier as the Bureau's unvarying protocol, Senator Patel said, and his voice had changed, not dramatically, not in a way that most observers would notice, but in the specific way that a very controlled person's voice changes when they are managing something significant beneath the surface. Investigative closure decisions involve complex assessments of evidentiary sufficiency, resource allocation, and prosecutorial viability. That were you involved in the closure decision for fine 2024 CR00091? Yes or no? I am involved in oversight of significant investigative matters across the Bureau. That is not a yes or a no. My office reviews closure decisions for matters of significant scope. So yes, you were involved. I reviewed the recommendation and approved it. Patel's attorney leaned in. The whispered consultation lasted 6 seconds. I approved the closure recommendation based on the assessment provided to my office. By whom? Another consultation by appropriate supervisory personnel. Can you name them? Silence. Here is where Crockett reached the center of everything. The moment the entire exchange had been building toward, she reached into her folder one more time and produced a second document. smaller, a single page, and held it up so the cameras could see it clearly. Director Patel, I want to read you something. This is your sworn testimony before the Senate Judiciary Committee dated February 19th of this year. I am going to read one sentence. She found the marked line, quote, "To my knowledge, no investigative closure decision made during my tenure has been influenced by communications with external parties outside official bureau channels." End quote. That is what you told Congress under oath on February 19th. She set the page down. You have now confirmed in this hearing, also under oath, that you conducted 38 off-channel communications with an outside law firm during a 51-day period. You have confirmed that no conflict of interest disclosure was filed. You have confirmed that you approved the closure of a $1.7 billion investigation during that same period, and you have been unable to name the supervisory personnel whose recommendation you claim to have relied upon. She looked at him directly. Director Patel, one of your two sworn statements to Congress is false. Either external communications did not influence closure decisions, which is what you said in February, or 38 off-channel contacts with a firm whose clients had active cases somehow had no bearing on a $1.7 billion investigation that was closed during the same period. She paused. Which sworn statement would you like to revise? The silence that followed lasted longer than any in the hearing. Patel's legal team was in urgent consultation, two attorneys simultaneously. The lead attorney finally straightened and addressed the committee chair directly, requesting that the witness be permitted to submit a written clarification of his prior testimony within 10 business days. Crockett looked at the chair, then back at Patel. I want the committee to note, she said quietly, that the FBI director, when asked which of his two sworn statements to Congress is accurate, has responded by requesting time to submit a written clarification. That response is itself an answer because a witness whose prior testimony was accurate does not need 10 days to clarify it. He just says it was accurate, and Kash Patel did not say that. She gathered her papers, 38 communications, $1.7 billion, one investigation closed without documentation, and a prior sworn statement that cannot survive contact with this committee's questions. She looked at the cameras. The American people can decide what that means. Here is what you need to understand about what happened in that room today. Crockett did not come to make accusations. She came to create a contradiction so documented, so grounded in the FBI's own internal review that there was no rhetorical escape. She established Patel's own description of bureau protocol. She produced a report showing 38 violations of that protocol. She connected those violations to a specific investigation closure, and then she produced the prior sworn statement that made all of it perjury, not alleged perjury, not possible perjury. A documented on the record contradiction between two statements made under oath. One that Patel's own legal team could not resolve in the hearing room and requested 10 days to address in writing. 10 days. The FBI director needs 10 days to explain which of his sworn statements is true. 38 off-channel communications, $1.7 billion, one closed investigation, one prior sworn statement, and a request for 10 days that told the room everything it needed to know. Subscribe right now, hit the bell, and share this video. The written clarification Patel's team requested is due in 10 days, and when it arrives, this channel will be the first place breaking it down. The contradiction is in the record. The investigation closure is in the record. The 38 communications are in the record. And somewhere in Washington, very expensive attorneys are trying to find a sentence that makes two incompetent sworn statements both true. There is no such sentence. And everyone in that room today knows